All right, the court will call the case of the State of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
Mr. Eric Martin, please unmute your device, and state your name.
Can you hear me?
I can now, sir.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family, a living sovereign.
Assistant Public Defender Davi Lebo as standby counsel.
Thank you. We're here for a pretrial today, and a bench warrant is still outstanding for Mr. Martin.
That's correct, Your Honor. As it relates to the pretrial, I believe the last time that we saw Mr. Martin, it was on December 7th, and he had some difficulty viewing the video that we had sent via flash drive. I encouraged him to get with his...
Welcome back, everyone. Today, we're diving into the chaotic courtroom saga of Eric Martin, also known as a loosely defined living man. He's back in the Michigan courts, and as always, representing himself. Now, for anyone familiar with the old saying, a fool for a client, this is peak material. What's wild here is that Eric is trying to argue the law as if he's the ultimate legal expert, questioning basic rules of traffic, licensing, and even the Constitution itself. But as you'll see, the judge and prosecution aren't letting him run the courtroom. Stick around because the twists, contradictions, and courtroom tension are absolutely insane. You don't want to miss a second of this one.
Standby counsel, who at that time was APD Sandra White. He did not appear at that next hearing, but she did confirm that they had spoken almost every day and that they had reviewed the video. So my understanding is that Mr. Martin has been able to view the complete discovery, including all of the media. I know that we were headed to a jury trial, so I will leave it to Mr. Martin to confirm that so we can get going with selection.
Mr. Martin?
Yeah, I looked at the video, and I looked at the video, and I also found some demands to dismiss, some self-incrimination based on the video, along with some others that have not been decided on, which should be decided on before any trial scheduled or anything else.
Mr. Martin, I've decided on all the motions that you've brought before me. And the way this works is if I make a motion ruling, then the party making that motion has to prepare the order. So when you complain about no orders being prepared, that's your not preparing them, sir.
What do you mean not preparing?
I think my words were very clear.
I understand what you're saying. You're saying because I didn't style it as a motion or something? What are you saying?
Right here is where the drama kicks into high gear. Eric Martin, representing himself, is questioning motions and dismissals like he's some legal prodigy. But here's the thing. The court makes it crystal clear that when a judge rules on motion, it's the filer's responsibility to prepare the official order. Eric's confusion and repeated objections are classic self-represented pitfalls. He argues the law, cites the Constitution, and thinks he's winning, but procedural rules are crushing him. This is a perfect example of why representing yourself in court is often a recipe for disaster, no matter how confident you are in your legal knowledge.
I already ruled on them. So when I rule on them, it's up to the party to prepare them. That's you.
I did prepare them. Specifically, my demand to dismiss.
Sir, you did not prepare my ruling order, which was that they are denied.
What do you mean they're denied, but you didn't rule on it? How does that happen?
Do you have anything else? Yes, Ms. McDuffie.
I'm sorry, Your Honor. I did just want to clarify one point because Mr. Martin, I think, mentioned that he wanted to move to dismiss based on incriminating statements after he had reviewed the video. So I don't know if there's a sort of Miranda issue he's raising or not, but I would just, I guess for the record, remind Mr. Martin that when he appeared for the hearing on the 5 documents that he filed, demands, motions, whatever you want to call those, Mr. Martin, during that hearing, rattled off the fact that he did not have a valid license, his vehicle wasn't registered, and he didn't have insurance and didn't feel like he needed to do any of those things. So if there are any incriminating statements that would relate to the counts in this case, he has made them multiple times, including on the record in this court at his own hearing. So if any statements were suppressed from that media, they would still come in from statements he's.
Now, watch closely. The prosecution brings up something critical. Eric has made multiple self-incriminating statements on the record. This is a key moment. He's arguing legal technicalities, but he's inadvertently providing evidence against himself. The irony is brutal. He's basically undermining his own defense by insisting the law is on his side, while the judge calmly points out that the statements he's making are enough to proceed with charges. This is why courtroom decorum and listening to your attorney, or even just procedural rules, matters so much.
Well, I object to the third one is self-incriminating. As I pointed out and stated in my demands to dismiss, as the U.S. Supreme Court said, license ain't necessary. We're not using the streets for profit, which the cops have no evidence.
Mr. Martin, you're going to need to speak up if you want to have a transcript of this, because it's not.
I'm speaking up.
Let's see, Heather. Okay. Can you bring the microphone closer to you, Mr. Martin?
Yeah, let me see.
I'm sorry.
Kind of a little closer now. How's that?
Is that any better?
How's that?
How's that? That one clear. Yeah, please keep talking in the same volume that you're using right now so we can hear it.
Well, I object to what she just said about I made some self-incriminating statements. That's not true, because as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus Banton case I cited and sent a quote from the law book on that clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration.
Here's where it gets truly cinematic. Eric begins arguing that the state laws are unconstitutional and that he's exercising his right to travel. He cites the Supreme Court, federal statutes, and even the 13th Amendment as if he's writing a lower review article mid-court session. But let's be real, the judge isn't buying it. The tension here is palpable. It's a mix of high drama and comedy. You can almost feel the courtroom collectively saying, please, stop talking. These moments are what makes self-representation both fascinating and painful to watch. Logic and emotion collide in real time.
So, nothing self-incriminating about what I say. There's no legit case here. And, which is why I beat a case on the same exact issue in Southgate. Same exact issue. Prosecutor moved to dismiss it because they know they had to win the case. The higher law is in my favor. The state law is unconstitutional. That's assuming everyone's driving a motor vehicle when they're not. And I'm working to change that state law, and I'm going to. I already got a federal lawsuit filed on it in the Detroit courthouse on Lafayette Boulevard. Right now I got to fight one about filing fees, but when I overcome that, they'll be deciding on the merits, and I will be winning on that issue. And the state law, it's unconstitutional. Cops are blindly following that, acting as if that, and then the so-called courts are acting on that presumption. No, everyone's driving a motor vehicle, they need a license, insurance. So no, they don't. They're not doing it for profit. They're exercising the right to travel.
So, Your Honor, since Mr. I'm sorry, Mr. Martin. Since Mr. Martin has again made those same statements that I referred to earlier, and this prosecutor will not be dismissing anything in this case, we will be proceeding to trial if he doesn't want to plead to it. Let me ask.
Next up, the calendar chaos. Eric struggles to grasp court dates, jury selection, and virtual versus in-person hearings. The judge patiently clarifies, but Eric keeps mixing up July 25th with August 9th. This might seem minor, but it's huge in the courtroom context. Missing a date can mean serious consequences. Plus, it highlights the challenges of representing yourself when the system operates with very strict timelines. The humor here is unintentional but irresistible, as Eric argues procedural technicalities while the court is simply trying to schedule the next step.
The court, if I could, are we ready to set this? I understand he has a desire to file an endless amount of lawsuits and grievances and motions, but the court has indicated we are past that point. Are we ready to set this case for jury selection or no?
Yes, we are.
Thank you.
All right, any motion that was just made, whatever he's entitling that, is denied.
So you deny some, you don't even know what it is. But anyways, you still have, there's still demands to dismiss that haven't been ruled on as a matter of law, which what a lot of them are, such as the state as a party. I filed a demand to dismiss because the state is the party here. Plaintiff. The state in this court, so-called court, has no jurisdiction, as I indicated in my demand under the U.S. Constitution. Only the
Sir, I'm not hearing those motions again. On October 26th, I made a ruling on all of those motions, and you have not prepared the order to that effect. We're done with those motions.
it's in order.
Is that the
So-
May jury selection, Your Honor, or?
No, it's not. We're gonna do a July 25th July 25th final settlement conference.
Okay.
August 9th. Jury
What?
selection.
July 25th, 2024.
Hold on, let me write this down here. And I'm also going to make a demand right now for compensation also for this making me proceed against my will under threat and duress to these so-called court proceedings in violation of my 13th Amendment right.
Now we hit peak courtroom absurdity. Eric claims the proceedings violate his 13th Amendment rights, calling the system slavery because he feels forced to appear. The judge's response? A firm reality check. This isn't Rosa Parks, and constitutional law doesn't work this way. This moment perfectly illustrates the clash between personal interpretation of the Constitution and actual legal precedent. For viewers, it's both educational and jaw-dropping. You see just how far someone can stretch constitutional arguments when representing themselves without grounding in case law.
All these court proceedings are against my right against slavery. So I'm entitled to compensation for all the court proceedings that I had to make in this case. Otherwise, I would have possibly been arrested. It was only under threat and duress. It wasn't by consent willingly.
Mr. Martin knows that the jury selection is in person, correct?
I haven't finished telling him all of that yet. I'm getting the dates. I'm gonna
Okay.
tell him in just one second.
Mhm.
All right. The final settlement conference in this case is going to be on July 25th, 2024 at 11 a.m. And that is on Zoom. The August 9th jury selection is in person, and that's at 8:30 a.m. on August 9th.
Hold on. July 25th, 24, right? 8 p.m. a.m. You said, right?
11 a.m., sir.
You know, I want to be understood. I'm not willingly giving up my right to be one of the sovereign people and by this jury, but you know.
Jury selection is August 9th, 2024 at 8:30 a.m.
The courtroom is wrapping up, and the judge decisively ends a hearing. Eric Martin, exhausted from his own arguments, finally has the session concluded. The professionalism of the judge stands in stark contrast to Eric's chaotic presentation. This is a textbook example of courtroom authority. The judge maintains control, enforces rules, and ensures the case moves forward, regardless of how entertaining or absurd a self-represented defendant may be. This is a real-world lesson in order, patience, and authority in the legal system.
You said 24th?
It's at 8:30 a.m. I meant to say 8:30 a.m.
You said the 24th now, or you say the 25th?
August 9th, 2024 at 8:30 a.m. is the jury selection, sir.
I thought you just said 7/25/24.
That is the final settlement conference. That is on Zoom.
Hold on, I got one thing at a time. Okay, now let's do the what's the other date now? August. What else?
August 9th.
Okay.
at
What time?
8:30.
8:30, and what's that considered, what's that called there?
Jury selection, sir.
Now, which is in person here now? The 7/25/24, is that something I have to be there in person for? I'm being
For the fourth
threatened to come
time,
up there.
Mr. Martin, please listen. The first event, which is in July, is on Zoom. The last event is in person.
So we got it. So we're saying a whole bunch of wonders.
All right, we're
Yeah,
done today. Have a good day, Mr. Martin.
To sum it all up, today's session with Eric Martin showed exactly why self-representation can be both entertaining and dangerous. From procedural missteps, confusing motions, and constitutional debates to mismanaged court dates, it's a whirlwind of courtroom drama. The judge consistently enforced rules, rejected baseless demands, and reminded Eric of the legal realities he keeps challenging. If you found this case as shocking, confusing, and fascinating as we did, don't forget to hit that like button. Leave your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.